Welcome back to the OMB Law Board. I'm Simon Bennett. I've got with me today Special Counsel in our litigation department, Jennie Goff. Jennie, welcome back to the OMB podcast.
Thanks again for having me.
So we're going to talk about all things litigation. Your department looks after all things litigation, which is a pretty broad topic. But, you know, for the non-lawyers out there, what is litigation?
Quite simply, litigation is the place you end up if you can't resolve a dispute in the first instance. Usually there's two parties in whatever form that looks like. They've got a dispute. They might perhaps try and resolve that dispute through talking, informal chats, informal dispute resolution, engaging a lawyer to have sort of a bit more of a formal dispute resolution. If they can't resolve, there's no meeting of the minds for whatever reason, it then goes down the path of litigation, which is a more formal process where you usually end up in court and you are actually looking for an independent person, i.e. a judge, to actually resolve that dispute for you that you just can't get to through the informal process.
So this is where we've got two, sort of an adversarial position. We've got two parties who are at loggerheads for one reason or another. It could be, an injury claim. It could be a property claim. It could be a contracting dispute or some other form of dispute between two parties. And the traditional methods of resolution haven't worked.
Correct.
And we're now in the OMB litigation department to help, get a result.
Yeah, help find another way. Because again, as you said, traditionally, they're the usual processes that one goes through, and sometimes that may involve lawyers, it may not, just have not worked, and that can be for a variety of reasons. It can be just, as you said, the minds just can't meet. It can be, people on different platforms. It can just be, there's an old adage of the principal, which can be very expensive adage.
Principals can be very expensive.
They can be very expensive.
So how can the litigation department help me resolve that dispute? And what are the different levers that you've got to pull, and what are the different mechanisms as a litigator that you can use to help me get a resolution in my dispute?
Okay. Well, at the first instance, when you come to the litigation department, we don't usually roll into litigation as our first point of call. We look at the whole, a holistic part of the claim, what's been going on, have there been some alternate options explored? Because at the first port of call, if you can find a resolution without going to court, it's always a really good option. Courts are expensive, courts are time consuming, courts are stressful, courts take away your own ability to have some kind of input, and they take away flexibility. So first port of call, we try and, I suppose, explore what options have taken place. So our role initially might be getting on the phone and having a chat to your opponent, writing a letter, trying to engage in some kind of more informal dispute resolution. However, if that doesn't work for whatever reason, we then look to commencing a court action. There's various courts in Queensland. You've got the district court, you've got the Supreme Court. It depends on what is the monetary value of your claim.
So how do we pick which court we're in?
Okay, so monetary value is number one. If for disputes around, say, $200,000, it would fall into the district court. For claims over $750,000, they go into the Supreme Court. Also different disputes. If you've got an equity dispute, it has to go into the Supreme Court. So there's various rules and reasons why a matter may go into a certain court. So that would be one of our first, I suppose, options.
And the other thing that always interests me is whereabouts would the action be brought?
Oh, okay.
What jurisdiction?
Okay, so normally, if something happened here, if the wrong happened around Southport, we would look to say, do we have a court that can hear the matter in Southport? So if it was a local court, magistrates court matter, we would have a nice court down the road where we could go and file a claim. You look to where the parties are. You look to where the action accrued. We would then lodge it here. If it's a matter that needs to go into the Supreme Court, normally we trot up to Brisbane and file it there. There is a court that does sit down here occasionally for the Supreme Court, but the sittings are very limited. So first port of call, we'd go to Brisbane. Of course, if it happened up in Cairns, they've got some courts and jurisdiction up in Cairns.
So I'm going to hit you with some hard questions here, because this is what our listeners want to know.
Yeah.
I mean, this is what people want to know about litigation, is how long is it going to take and how much is it going to cost?
Two very good questions, and the answers you give are often not what people want to hear. Litigation itself, court process can take a long time. Some people think it's a very short process, 1, 2 days, 3 weeks, 4 weeks. No, it can take well in excess of 18 months, 2 years on occasion, sometimes even more. You can go through the initial process and have your initial hearing. Sometimes it doesn't stop there. There's always an option for the party who loses to actually appeal if there's legs for them to appeal. It can then go to another court. So it can go on for years and years and years. Of course, longer the time, the increased cost. Courts are expensive. It is really your last port of call. Sometimes we've got no option. We have to go that path.
Okay. Next question is, if I win litigation, do I get my cost paid?
Okay, very good question again. With costs, if you win your litigation, you will get some of your costs, and that will depend on how the matter has progressed. Without boring our viewers with too much detail, there's what we call standard costs, there's what we call indemnity costs, which are more akin to costs awarded if you haven't done the right thing along the way. You get a little bit more of your costs if you win your case. So you won't get all of your costs, you will get a portion of your costs, and they will have to be assessed. That is another process unto its own, it's a beast of itself. Just because you get a cost order, because you've won, the other party, who is usually disgruntled from having lost their case, is then not going to readily agree to pay your costs. We have to go down the procedure of having the file costed, getting a cost assessor involved, usually filing another application to the court if they disagree with our costs. So again, it's another protracted procedure.
And then enforcing that order to actually, before you get the cash in your pocket.
Absolutely. So,
but in the meantime, you've got to fund all of this process.
You do. So again, while we go back to the very beginning, if there's an alternate dispute resolution option for you, have a really good hard look at it.
So we generally think about litigation as the action of last choice. You don't want to have to be involved in litigation. Sometimes you have no choice. You may have litigation brought against you and you have to defend it. Alternatively, sometimes the only way to proceed with the party not willing to negotiate reasonably with you is to take that course of action.
It is, and sometimes it's the first step. Just because you commence a proceeding, it doesn't mean that you're going to go all the way to court. Sometimes it's a bit of a process. Okay, I will commence, and we will commence the proceeding. And sometimes the other party needs you to take that step to know that you're taking the matter seriously. Once you get to a court as well, it also becomes more of a public process. People don't like that. Companies don't like that. So sometimes once you make that first step through various reasons, there is still many opportunities for you to have mediation, alternate dispute resolution, other processes where you can have that conversation along the way to the judge.
Well, Jennie, thanks so much for drawing back the curtain on the litigation process and what's involved. And, I'm sure our listeners have found it as informative as I did. Just understanding what's involved if we can't resolve it, obviously hoping that we can, but if we can't, that there's still other avenues, and the litigation team here at OMB is more than happy to assist.
Absolutely, and that's our role, to have a chat with you, give you some just a good solid advice, and then take the next step.
Well, thanks for coming in today.
You're welcome.
And appreciate you listening all the way through. And if you've got any questions for our litigation team or problems, contact the OMB litigation team or drop us a comment below. And we look forward to seeing you on the next episode of the OMB Law Board.